Welcome to today's episode of the Law of Self-Defense. Thank you all for being here. My apologies for a few minutes delay. This is going to be an in-depth course of instruction on the legal presumption of a reasonable fear of imminent deadly force harm at the hands of a home invader under the circumstances in which the homeowner is firing at the home invader through a closed door. Yes, this has to do with that apartment shooting in Dallas, where two home invaders start off pretending to be maintenance people at the apartment, attempt to get voluntary access by fooling the apartment residents into letting them in. When that doesn't work, they start kicking in the door. And the apartment dwellers respond by pew, 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 firing shots through the closed door into the corridor, the public corridor, the common space corridor of the apartment house. We have this captured on doorbell type video, so we'll be watching that. I will be sharing this video for everybody. We should be streaming on YouTube, and I see we are. And we should be streaming on Rumble, and we are. And on the home of Law Self-Defense member dashboard. And we are, and finally, on Twitter. And we are. So normally when I have these use of force videos, I'll first talk about the law for all the channels on which we're streaming. But before I go do our analysis of the actual video, I usually cut off the public streams and limit it to our members. We're not doing that today. I normally do that because the videos often involve people being shot and dying, and I get demonetized on YouTube when I show those. But I don't believe anyone was actually struck by any of the rounds here. So we'll give it a shot and see if I get demonetized on YouTube today. In fact, I wonder if I can tell if I'm already demonetized. Not yet. Not yet. So far, we're all good. So there will not be a point in the show at which we cut off the public streams. Everyone's welcome to stay for the entire show. As normal, however, we only take questions and comments from our Law of Self-Defense members on the Law of Self-Defense dashboard. So along those lines, you might consider becoming a Law of Self-Defense member. Again, normally when we do these video analyses, we cut off the public streams. Only members get to see our breakdown of the video itself. That's part of the benefit of being a Law of Self-Defense member. We only answer questions and comments from Law of Self-Defense members. Law of Self-Defense members get transcripts of every show if you prefer to read rather than watch lengthy video, and you can download the transcripts for your own records to document your specialized knowledge should you ever need to document that knowledge as part of your legal defense in court. All benefits that only members get. And Law of Self-Defense membership is dirt cheap. In fact, you can try it out for 2 weeks for just 99 cents, unlimited member access to all our content and benefits. And if you stay a member after that 2-week period, it's still cheap. It's only about 30 cents a day, less than $10 a month to be a Law of Self-Defense member. You can take advantage of that 2-week trial at lawofselfdefense.com/trial. Now, in today's show, I will, of course, focus on this Dallas apartment shooting event. We'll talk about a number of legal issues there. But I also want to touch on some other cases that also involve home invasions or apparent home invasions and illustrate how they're treated differently in different jurisdictions. So I often say self-defense is about 80% the same across the 50 states. The 20% difference does matter. Does matter. The 20% difference can mean the difference between conviction and acquittal or not being charged in the first place. But things get even worse when we're talking about defensive property and defensive habitation. So defensive habitation, defensive dwelling, defense of your castle, that law is different than defensive persons. It's similar, but different. And it varies a lot more across the 50 states than does defensive persons. Defensive property, like personal property, really doesn't vary much at all, except for Texas. And of course, this apartment shooting did happen in Dallas, but it shouldn't be relevant to the facts of this particular case. So with that out of the way, let's go into the formal launch of today's show. Here we go. Okay, so because we're not cutting off the stream when we get to the video, I won't play the video at the end of the show today. I'll play it at the beginning, and then we'll see if we get demonetized. Thanks, YouTube. So we'll see what happens. But what we will see is a gentleman standing outside an apartment door. It looks like he's being filmed like through one of those old keyhole spy things, the little glass things in the door. But obviously it's recorded. I assume it's some Ring type camera. And he's knocking on the door. He's wearing a blue bandana around his head. He's dressed as if he were a maintenance worker. And he's pretending to be a maintenance worker. He wants to come into the apartment, he says, because they need to change the filters, I guess, in the HVAC system. There is someone inside the apartment conversing through the door, the closed door. There actually turns out there's two people inside, but at least one person's conversing through the closed door and appears to be disinterested in allowing this dude into his apartment. And when the fake maintenance worker gets that news, he pretends to be polite, but pretty quickly he starts kicking at the door. Not behavior consistent with a maintenance worker, is it? And it turns out that he's got a masked buddy in a red shirt who also starts kicking at the door. And they're pretty strenuous about it. I mean, they're trying to get this door open. So it would be nice to know what kind of door security this dude had, because most doors, especially, I mean, most of us have lived in these kinds of apartments at some time in our life. They're not that hard to open up. And these dudes are really struggling, and they never really do get the door opened up. By the way, there are ways to augment those doors. Remember, the whole purpose of a door is not to be impervious to entry. Give someone enough time, they're coming in. It's to slow them down long enough to get to your defensive measures so you're able to deal with that problem. And this door certainly served that purpose effectively. At some point, however, the apartment dweller decided he'd had enough. He wasn't going to wait for the door to get kicked open. The door was still closed, presumably locked, and the apartment dweller starts firing rounds through the door into the common space of the apartment building, and there's another apartment right across that corridor. And you can see the rounds start hitting the wall on the other side of the corridor. And then the video continues and the police show up. We'll watch that part too, but really for use of force purposes, everything's pretty much ends there, although I do have some comments on the police interaction as well. So with that all framed out, let's go ahead and watch the video, and then we'll dive into some of the legal issues. So let me hop over here. Let's see, maybe this would be better. Whoops, that's not at all what I wanted. All right, here we go. So this is the head of the fake maintenance worker right here. And again, I don't believe anybody was even struck by a bullet. So there's no gore, there's no blood, there's no injury here. Hear me, YouTube? Nobody was even hurt, except for the far wall. And that's the other apartment, presumably innocent bystanders, right? The other apartment across the corridor there that is downrange of the rounds being fired by the apartment dweller. So here we go.
No. Yeah, we're checking the air filters. Oh, much appreciated.
Much appreciated. Still pretending to be a maintenance guy, just wants a running start at the door. Bam! Here's his buddy. Gloves and a mask. They're trying. That's a lot of rounds across that corridor.
Dallas police. Yeah. Mr. Rodriguez, Ethan, it's Dallas police.
All right, so let's go back to the use of force. I will cover the police stuff too. A few things we know here. So, of course, we have a variety of justifications for the use of deadly defensive force. This was clearly the use of deadly defensive force, right? The firing of rounds intended to strike an aggressor. We have self-defense, independent of being in a dwelling, right? Just self-defense. What's the justification of self-defense? It's the 5 elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. Innocence, are you the innocent party? Is the other party the unlawful aggressor in the fight? Imminence is the threat you're defending yourself, either in progress or immediately about to happen. Did I want to say anything more about that? Proportionality is the degree of threat you're facing only non-deadly force threat, in which case only non-deadly force can be used, or is it a deadly force threat, in which case deadly force can be used? Avoidance, do you have a legal duty to retreat? This happened in Texas. Texas not only has no generalized legal duty to retreat, it's a stand your ground state. It's a hard stand your ground state. The jury's not instructed. They're not even allowed to consider the possibility of retreat in evaluating the reasonableness of your use of force in self-defense. So avoidance is completely off the table in Texas in an otherwise lawful case of self-defense. And reasonableness, were you reasonably perceiving what was going on? And in the context of reasonableness, this video is very helpful. And there would also be a defense of others defense, because there is a second person inside the apartment. So the person who fired the rounds could argue, I wasn't just defending myself, self-defense, I also have a defense of others justification. It's probably not the strongest justification, though. Probably the stronger justification would be defense of dwelling, defense of habitation, because you could argue that some of the elements here for self-defense have not yet been satisfied. At the very least, it's ambiguous. Clearly, innocence is satisfied. Someone's trying to force their way into your apartment, right? You're the innocent party there. They're the unlawful aggressor. But what about imminence? Are they an imminent threat when they're still on the other side of a secure, unbroken, locked door? Or is imminence not achieved until they've actually broken the door, or at least begun to break the door, right? The door being broken is about to happen. It's ambiguous. You could make an argument either way there. What about proportionality? Are you facing a deadly force threat? Well, maybe. I mean, two aggressors, right? But there's two people inside the apartment too. So there's no disparity of numbers. I haven't seen any weapons displayed. And you can't just speculate that there's weapons. So there's room to argue on proportionality as well, if we're talking straight up self-defense, defense of others, independent of the whole dwelling situation here. Again, avoidance is off the table. Reasonableness, I mean, you're reasonably perceiving someone trying to break in your house as supported by the camera footage. But are you reasonably perceiving imminence and reasonably perceiving proportionality, a deadly force threat? Those are things an aggressive prosecutor would argue. Fortunately, we don't have to worry about any ambiguity in the defense of self or defense of others. Oh, by the way, you can get this Elements of Self-Defense cheat sheet, folks, for free. We make this available for free. lawofselfdefense.com/elements. It's just a PDF download. We don't ask a penny for it. If you don't understand these 5 elements of self-defense, you certainly can't understand use of force law at all. If you do nothing else, I mean, just get the free download. lawofselfdefense.com/elements. But fortunately, we don't have to rely solely on those 5 elements, because we have another justification because of the context of the dwelling, of the castle, of the habitation. Most states provide an additional justification similar to, but independent of, duplicative of self-defense and defense of others, independent of defense of persons. They provide additional privilege for the use of deadly defensive force in the context of your home. Sometimes also your place of business, sometimes also your occupied vehicle. Why? Well, because your home is your castle. Your home is serving the function of providing a place of shelter and protection for you. Even in states that normally have a generalized legal duty to retreat, for example, before you can use deadly force in self-defense, every one of them relieves you of that duty if you're defending yourself from an intruder attempting to or in your home. The whole point of a legal duty to retreat is the theory that you would have a safer place to go if you retreated, that you could achieve safety without having to fight. You could achieve safety by simply withdrawing from the conflict. But if you're already in your home, what's the safer place than your home? Your home is supposed to be your ultimate refuge of safety. So even Massachusetts relieves you of your otherwise existing legal duty to retreat if you're defending yourself against a intruder in your home. So this happened in Texas, in Dallas, and of course, Texas, like other states, also has these kinds of legal provisions that give you a special privilege for the use of force in self-defense in the context of defending your habitation against an intruder. And Texas does it the way most states do it. They do it better, but generally speaking, they do it the way most states do it. And by that, I mean they create a legal presumption that you had a reasonable fear of imminent deadly force harm at the hands of this intruder. Simple enough, right? But if you think about what I just said, that legal presumption is giving you really all the elements you need for a lawful use of deadly defensive force. The jury's being told these elements are presumed to exist. So it creates a legal presumption that you had a reasonable fear of imminent deadly force harm. Well, the legal presumption is that you had a reasonable fear of imminent deadly force harm. That's 3 of the 5 elements of self-defense right there. 3 of the 5 elements you need to justify your use of deadly defensive force. Of course, avoidance is off the table in Texas. As I said, it's a hard stand your ground state. But even if this were Massachusetts, you wouldn't have the element of avoidance because you're defending in your castle. The castle doctrine would relieve you of any element of avoidance. And of course, innocence, the last element, is kind of baked in the cake when you're lawfully in your home and you're dealing with someone unlawfully and forcibly trying to intrude in your home. So this legal presumption is very powerful. Essentially, it gives you a blanket justification for the use of deadly defensive force if you meet the conditions of the statute and you don't trigger any of the exceptions or exclusions from the legal presumption. Now, I'll tell you up front, if you do trigger one of the exclusions from the legal presumption, what you've lost is the legal presumption of these elements. You still get to argue standard self-defense and standard defense of others. You haven't lost your privilege to use force in defense against these intruders. You just have lost the benefit of the legal presumption. The jury wouldn't be told that they are to legally presume that these elements are present. So with that said, let's take a look at how Texas structures this legal provision. And I'll explain also why they do it a bit better. Actually, before we jump into that, let me see if there's any initial questions from the Law of Self-Defense chat that I need to address since we're about 25 minutes into the show. Or 18, sorry, I started late, 18 minutes into the show. And by the way, this Texas law I'm about to show you, this slide deck, this is from our Texas-specific law of self-defense course. We have state-specific law of self-defense courses for every state, obviously including Texas. This is just one portion of the Texas course, the defensive property court portion. There's 12 sections in each of our state-specific courses. If you're interested in the state-specific course for your state, just go, the banner's at the bottom of the screen there, go to lawofselfdefense.com/state, and I think there's a 60% off sale right now. If you want to take advantage of that. But we have it for whatever state you might be in or be interested in or want to visit. Okay, yes, the chat. Let me take a look so everything doesn't pile up too big. And we'll discuss both the legal and the tactical dynamics of this decision to shoot through the door. Let's see. Lobsters, everyone's talking about lobsters for some reason. It's lobster is very overrated. If you've ever lived in New England, you know this. Let's see. Hey, Steve Gosney's in the chat. Hey, Steve. Someone says there was a firearm in the guy's hand. Well, we'll play the video again and look for it. I didn't see that on first view, but it may be the case. And of course, it would be important if the people inside the home saw that, right? That would clear away any ambiguity about proportionality. Let's see. Yep, lots of ways to harden up your exterior doors and also interior safe room type doors, folks. Okay. All right. So Texas, let's take a look at Texas law here, again, from our Texas specific law of self-defense course. I'm going to skip over most of this. It covers, of course, Texas is the one state in the nation that does have a provision for the use of deadly force in defense of mere personal property, even independent of any defensive habitation argument. In every other state, you simply are not permitted to use deadly force in defense of mere personal property, absent a threat to persons or some other independent justification for the use of that deadly force. It is Texas Penal Code 9.42. I'm not going to dive into that today. We have enough to talk about. But if you'd like to read the statute, you can always go to lawofselfdefense.com/942 and read the statute yourself. And I would encourage you to do that because it's important to understand there's a lot of conditions that have to be met to qualify for that statute. And if you fail to qualify, and many of those conditions are based on reasonableness, and reasonableness is not really your judgment of reasonableness. That's not what controls your legal outcome. It's what other people find reasonable, right? The jury, for example. And if they disagree with you, you don't qualify under 9.42 and off to prison you go. But you can find that again at lawselfdefense.com/942. All right. But we're not here to talk about personal property. We're here to talk about highly defensible property. So 2 buckets of property for use of force law purposes: mere personal property, items, your phone, your unoccupied car, stuff, your barbecue outside your house. Then there's highly defensible property. Highly defensible property tends to be property that has as a function the shelter and protection of people. So it always includes your home, your habitation, your dwelling. Often, depending on the state, includes your place of business. Often, depending on the state, includes an occupied vehicle because there's people inside it. That changes the character of the property. An unoccupied car is personal property. An occupied car may be highly defensible property, depending on what state you're in. And it's important to keep in mind that these special provisions that allow for the use of deadly force in the context of highly defensible property, what they're not doing, what they're not intended to do, is allow you to use deadly force to defend that property literally. You're not really being allowed to use deadly force to protect the scuff marks from being put on your door when someone's trying to kick it in, or the shingles on your house, or the antenna on your car if someone's breaking that off. The purpose of these special provisions for the use of deadly force in the context of highly defensible property is that because it is highly defensible property, because it has that shelter and protective function, it's acting as a surrogate for the people inside the vehicle. It's providing an earlier tripwire to privilege the use of deadly defensive force without requiring the normal 5 elements of self-defense in the usual way, because someone's attempting to breach the shelter and security of the people inside. Fundamentally, it's still the people inside that are being protected, not literally the property itself. So Texas helpfully provides some definition of what they mean by these terms: habitation, vehicle. I don't know how much I'm going to dive into those. I don't think I will, because we know it's an apartment, so it would obviously qualify under these provisions. So Texas Statute 931, which we're not showing here, is use of non-deadly force in defense of persons, self-defense, or defense of others. Penal Code 9.32, which is what we are looking at here, is Texas deadly force in defense of persons. So it covers self-defense, covers defense of others, the normal defense of persons, use of force, justification, but it also has special provisions that you might think of as what many states put in separately as defense of highly defensible property statutes. They would have a separate highly defense of property statute that would include this kind of legal presumption we're talking about, which makes it sound like a defense of property provision. But what I've already told you is it's really not. It's really just the property acting as a surrogate for the people inside the property. It's the people really being protected. Texas appropriately takes those special provisions, does not put them in a defense of property statute, which would be misleading and incorrect from a doctrinal point of view, it puts them within the defense of persons statute, which is where they should be. So they have the various conditions for the use of deadly force in defense of persons. Let's see, did I even bother putting that here? No, but that's just the 5 elements of self-defense, okay, with the exclusion of avoidance under Texas law. And those are found in, so Texas A2, section A2 is the deadly force in self-defense section. Here, paragraph B begins the special provisions for the use of deadly force in defense of highly defensible property, in this case, habitation, this dude's apartment. And it reads, the actor's belief under the deadly force justification section that the deadly force was immediately necessary. So immediately is imminence, deadly force is proportionality, is presumed to be reasonable. There's the element of reasonableness, 3 of the 5 elements. If the actor knew or had reason to believe that the person against whom the deadly force was used was doing one of several things. Let's take a look at those several things. Now, one of the reasons I say Texas is better than some of the other states we're going to talk about today is Texas explicitly says knew or had reason to believe. There are other states in which a distinction is made between whether or not an intrusion, an unlawful intrusion, was actually taking place in order to trigger this legal presumption, or whether it's sufficient that the defender reasonably believed that an unlawful intrusion was taking place. You can see how that could be a problem, because you can see how a defender might think someone was trying to break in, maybe not on the facts of this case, but you can imagine other facts. Someone might think, and we'll have a case where someone did think that mistakenly. Someone mistakenly thinks there was an intrusion. Now, under Texas law, if they had reason, if that was a reasonable mistake, they had reasonable reason to believe that an unlawful intrusion was taking place, well, then the presumption would be triggered, even if they were mistaken. But if the requirement, and we'll see a state in which this is the requirement, if the requirement is that a reasonable belief of an unlawful intrusion is not enough, it has to be an actual unlawful intrusion. Doesn't matter how reasonable the belief was, then you don't get the benefit of the legal presumption. The jury does not get that instruction. Texas doesn't have that problem because they provide for both. New suggests that there was an actual intrusion taking place or had reason to believe, would simply be a reasonable belief, even if mistaken. So that the person against whom the deadly force was used was engaged in certain behavior. What is that behavior? 1, they were unlawfully and with force had entered or were attempting to enter unlawfully and with force the actor's occupied habitation, vehicle, or place of business or employment. So this part of the statute tells us several things. 1, that Texas has a very broad definition of highly defensible property. Not as broad as possible, but pretty broad. A lot of states would only cover your home, your habitation. The next step would be for a state to cover your place of employment. Often it has to be your business, but at least you have to be employed there. The next step in expansion of the definition of highly defensible property would be a place of business, even if you're just a customer there. And finally, the biggest expansion would be also a vehicle. But in all these cases under Texas law, it only applies if it's an occupied habitation, vehicle, place of business, or employment. So if you're observing your home from outside and someone's trying to break in and you know you live by yourself, your home's unoccupied, well, you could still use force to prevent harm to property, but you wouldn't get this particular legal presumption. Same with a vehicle, place of business, employment, for example. And note also the requirement that the intrusion has to be both unlawful and with force. And I've talked about this before many times. Why require both? And not all states do require both. For some states, unlawful entry is sufficient. But most states that have these legal presumptions of reasonable fear require both unlawful and forcible entry. Why? because they're concerned about the innocent intruder, someone who's present unlawfully, but not with malice, not with the intent to do anything bad, to commit a felony or harm anybody. And you might be wondering, how can that happen? Well, it actually happens all the time. This happened actually in Dallas. The case of the police officer who went into the wrong apartment and shot the black gentleman who lived in the apartment, thinking she was in her own apartment and he was an intruder, right? It turned out in her apartment that something like 30% of the residents in that apartment building had either themselves, because all the apartments looked so similar, had either themselves walked into someone else's apartment by accident, thinking it was theirs, or had that happen to them, that somebody had thought they were walking into their own apartment and had walked into someone else's apartment. So it was pretty common in that building. It actually happens all the time, especially if there's like out-of-town visitors, right? We've probably all lived in these apartment buildings where they're like completely homogenous. Maybe not to us who live there, but certainly to a stranger who's never been there before. It's not at all hard to walk into the wrong apartment. Or you might be a dishwasher repairman who's given an address and said, hey, the residents can't be there, but they're going to leave the back door open so you can get in and fix the dishwasher. But the address he's given is incorrect. So he goes to the wrong home. Sure enough, the back door is unlocked. He walks in. He's not lawfully present. He's unlawfully present. He does not have license to be in that home. But in all these cases, the person who's unlawfully present is not there with malice. And the state does not want to give the benefit of this legal presumption to use deadly force against the innocent intruder. The with force requirement eliminates the ambiguity. There may be an innocent explanation for why someone's standing inside your front door, but there's no innocent explanation for why they would have broken something to get in, right? So the with force removes the ambiguity from there. And this, of course, applies whether they're already in, they have unlawfully or forcibly entered, or they're attempting to unlawfully and forcibly entered. So this is the first condition that triggers the legal presumption. Or an alternative trigger is that they were unlawfully and with force were attempting to remove someone or had removed someone. So this is kind of a kidnapping scenario. Or they were committing or attempting to commit an offense described by subsection A2B. What's A2B? It's a list of kind of enumerated personal felonies: aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, aggravated robbery, all felony offenses. Now we have the exclusions. So if those conditions are met, you get the benefit of the legal presumption, but now they have what I would characterize as exclusions. One, you must not have provoked the other person. If you provoked the other person, you might have met all the earlier conditions. You don't get the benefit of this legal presumption. Also, you can't be engaged in criminal activity other than a Class C misdemeanor, whatever that is. So if you're using your home to deal drugs out of, you're not going to get the benefit of this legal presumption, for example. And then we just have the jury instruction that does the same stuff. So let's take a look again at this video in the context of that Texas statute. Where are you? Here we are. Okay. And it's rewound back to the beginning. And the question is, of course, have these conditions been met? Right? This legal presumption of a reasonable fear of imminent deadly force harm is triggered. Was it triggered here? Did this apartment dweller know or have reason to believe that the person against whom he's using deadly force was attempting to enter unlawfully and with force the actor's occupied habitation without the dweller committing some crime within the apartment or using it for criminal activity? That's the question here. So let's take a look at the video and see what we see.
No. Yeah, we're checking the air filters. Much appreciated. 872.
Oh yeah, there's the gun. Thanks, guys. Okay, so clearly the guy with the blue bandana had a pistol in his hand there. Thanks for pointing that out, Steve Gosney and others. So there's no ambiguity about proportionality. Clearly there was a deadly force threat. And by the way, any state in which someone's forcibly entering your home with the apparent intent to commit a felony therein, and there's no other explanation for them having a gun in their hand, would privilege the use of deadly defensive force. I mean, it's straight up self-defense would do that, right? So clearly these guys meet the conditions of this Texas statute. Now, what kind of criminal liability might these guys be facing if they didn't have a justification for the use of deadly force? Well, if they had shot or hit one of these dudes and killed them without the justification, they could be looking at murder or manslaughter. We don't have to worry about that with respect to these intruders. Similarly, if they had only injured them with gunfire, they might be looking at aggravated assault, maybe attempted murder. But again, we don't have to worry about that with respect to these intruders. The defense of habitation, the reasonable presumption statute would protect them against liability with respect to the two guys trying to break in. But what about other people? So there's an apartment right across the hall. Now, the way the rounds, you can actually, on my monitor, I can see the bullet holes, marks in the wall. And the way they were powdering when they hit the wall is suggests to me the wall may be, cinder block, concrete, poured concrete, maybe. So the rounds were not penetrating into the apartment. But certainly, look at the door. Traditional kind of 6-panel door. Even if it's steel, it's not solid steel. It's just steel on the surface with a foam center. Even pistol rounds will punch through that pretty readily. Did they commit an act of reckless endangerment here to the innocent parties in that other apartment? I mean, did they put them at risk of death or serious bodily injury? I mean, they didn't know where they were shooting. Really, did they? It doesn't seem like it. Now, we don't know what they said, of course. I don't have any evidence about what they might have made statements about. But when you're firing rounds in this scenario, is it possible rounds go through that door and strike and kill someone or maim someone, man, woman, child in that apartment? They're not doing anything wrong. Why should they get shot? Well, reckless endangerment, recklessness, of course, is the creation of a substantial and unjustified risk of death to another and deliberately ignoring that risk, and then death results. That's what reckless manslaughter is. The Alec Baldwin situation, right? In his case, he pointed a loaded gun at a woman and killed her with it. Arguably not intentionally, but he didn't ensure the gun was not loaded before he pointed the gun at her, killed Helena Hutchins. We'll have a case about a show about Alec Baldwin this week, by the way, because there's some suggestion that the charges, he was charged with manslaughter originally. The charge was dismissed back in April without prejudice. So the prosecution is reserving the right to bring the charges back. And there is some new interesting evidence in that case. So maybe he'll be recharged. We'll see. But that's a different show. Here, of course, what the apartment dweller who fired the shots would argue is that perhaps I did create a substantial risk of death to others, but the risk was not unjustified. It was justified under this defensive habitation provision, this legal presumption provision. It would be interesting to know, because it is somewhat remarkable that every round hit what appears to be a cinder block wall, which I would argue is, at least with pistol rounds, you're not likely to create a risk to anyone on the other side of the wall. All the rounds appear to have hit the wall and not the door, which would be no protection at all from gunfire. Was that intentional? Did they know where they were shooting? Or did they have an awareness of the angle? Because it appears they shot through their own door, closed door. So clearly the bullets go right through a door, right? Did he make a deliberate decision to fire through his own door? Assuming, obviously, it appears these doors are directly across the corridor from each other. Did he make a deliberate decision to fire at an angle? Which would also explain why he missed, right? Because when he starts firing, where is the bad guy? See if I can catch that. The bad guy's right there. So did he make a deliberate attempt to fire off on a rightward angle to avoid the risk of shooting through the door and endangering someone, even though he knew it would mean missing the actual aggressor trying to kick the door in? perhaps that would be very helpful evidence to avoid a reckless endangerment charge. It would be evidence helpful to have in the record sooner rather than later, not just said for the first time at trial. That doesn't mean I'd want him explaining all this to the police at the scene. That's something you would explain to your attorney. Your attorney would explain to others. So now we have some things going for us here that are not always automatically the case. We have this video. How would this be different if we didn't have the video? Because the video removes a lot of ambiguity, right? It's pretty, one guy's got a gun, they're forcibly really hard trying to kick this door in, removes a lot of ambiguity. But if we didn't have the video, what would we have? Because the bad guys ran away and they're not going to provide testimony incriminating themselves, obviously. So they're gone. So when the police show up, what do they have? They have the word of the apartment dweller. They have the holes in the wall, whoever reported the gunfire. But there's no substantive evidence about the degree of threat or the attempt to enter the home. The door was not actually breached, right? So it's not like the door is broken open. Might there be scuff marks on the door? Maybe there's a boot print on the door. All right, well, that would be evidence consistent with someone maybe attempting to get in, maybe someone just angry over something, making a statement, leaving a boot print on the door, not actually trying to breach the apartment. So the video is very helpful here for the guy who fired the shots, for the defender. And many of us have security cameras, right? Ring doorbells, wired cameras, whatever the case may be. I can tell you, I've got them everywhere. For this purpose, by the way, and not to deter someone. Criminals don't really care about cameras in the moment. But so I'll have a record of what happened. And I have cameras facing out from my door, and I have cameras facing towards my door. So they also capture the rear of whoever may be at my door. Because I'm trying to create an evidentiary record that would be helpful to me, right? That would be supportive of my use of force decisions. To me, that's the real purpose of the video. But you never really know if you have the video, right? Ring doorbell cameras operate off batteries. Sometimes the batteries go dead. Mechanical stuff just fails. Electronic stuff can just fail. Maybe there was a lightning strike near your home and it just fried all your Ring cameras, fried your Ring doorbell. You never even noticed. So you don't really know you have the video until you go check and find out you have the video. So something to keep in mind. It's I would discourage you from making use of force decisions on the grounds that you have video. The video should be thought of as a bonus if it turns out you actually do have it. Don't presume you have it just because you have a camera set up. Now, one alternative here is there are, of course, like the Ring systems, for example, you can get these little displays inside your home or on the app on your phone where you can be watching the image from the camera in real time. I think then it's safe to presume that it's being captured, and it enables you to make tactical decisions based on what's actually happening, what's on the other side of that visual barrier, because you can get the benefit of the camera angle. It would be interesting to know if these guys were doing that, right? Were they actually viewing all of this in real time, especially when they decided to start pressing the trigger? That would be interesting to know. So, as I mentioned, Texas, very helpful here because Texas allows for this legal presumption if the defender knew or had reason to believe that this unlawful entry was happening. It doesn't require that the unlawful entry was actually happening. But that's not always the case. That is not always the case. So we have, or at least sometimes it's argued that it's not actually the case. And I have a couple of cases from other jurisdictions that I'd like to share with all of you. The first of these is from New Mexico. And I should say it was brought to my attention by Mike, who I believe is a Law of Self-Defense member. He sent me an email this morning. Thank you very much, Mike. I really appreciate that. Before Mike's message, I was not familiar with this particular case, but it's very much on point. So let's see. Let me pull this down. Okay. All right. So this is the case that we'll be discussing. Before I do that, though, let me take another quick look at the chat. Yeah, the Dallas, the female cop in the wrong apartment. That was the Amber Geiger case. Thanks for refreshing my recollection there. Let's see. Law self-defense member Eric says, yes, I saw a gun. Yep, I've seen the gun now too. Plus, Castle Doctrine presumes deadly force. No, nope, it doesn't. Castle Doctrine is often used, the term Castle Doctrine, too broadly, as Eric's using it here. Defense of highly defensible property, if it gives you that legal presumption we're talking about, that presumes deadly force. But Castle Doctrine by itself doesn't do that. Every state has Castle Doctrine. Not every state creates this legal presumption of a reasonable fear of imminent deadly force harm. Those are two different things. Castle Doctrine, defense of highly defensible property are two different things. The only thing Castle Doctrine does for you, properly understood in its historical context, the thing that every state has, is it relieves you of an otherwise existing legal duty to retreat when you're defending against an intruder in your home. It takes away the element of avoidance. That's it. That's all Castle Doctrine does. Defense of highly defensible property, if it creates this legal presumption, can take away other requirements because it creates a presumption that you had a reasonable fear of imminent deadly force harm. It actually doesn't address the duty to retreat at all. It leaves that to Castle Doctrine. So Castle Doctrine touches on avoidance. These legal presumptions touch on reasonableness, eminence, and proportionality. So two different things. Now, in fairness, it's very common, even for the legal profession, to use Castle Doctrine to mean more than just avoidance, to mean these other things too. That is simply sloppy legal reasoning and sloppy legal communication. It's a indicator of someone who's not actually expert at what they're talking about because they're conflating distinct concepts. Let's see. Jeffrey says, I'd still wait till they breach the door. AR in hand, focused on the door with cover in between, more defendable in court. That would be more defendable in court, right? So if the facts here, pretend we didn't have the video and the cops show up and there's a door with a scuff mark on it. Now the apartment dweller saying these guys were kicking the door like crazy, but there's no physical evidence of that because the door wasn't actually breached. That's a different scenario than if the cops show up, there's no video, the apartment dweller saying, yeah, these guys were kicking the hell out of the door and the door's actually been kicked open. Or the frame is cracked, right? There's objective evidence of an imminent breach or actual breach of the door. So the second scenario obviously is more defensible because it removes the ambiguity about whether or not somebody was trying to come in. More defensible in court. The flip side, of course, is that it's less defensible tactically. And you do have to win the physical fight. So that's a tactical decision you need to make. Do you wait for the door to be breached? Well, then the bad guys are inside your home with a gun. Now you're in a gunfight inside your apartment. Now, if your apartment is, prudently arranged and you have a good position of not just concealment, but cover, cover's never 100%, right? At least your eyeball has to be visible if you're using sights on your gun. You can mitigate the tactical risk, but obviously it's more tactical secure to fire through the door like these guys did. So your fire is a complete surprise to the bad guys, but less legally sound. So there's a trade-off there that each of you have to decide. And I'm not telling you to never fire through a door. I'm just telling you that it increases your legal risk. Where you draw that balance is a decision only you can make. I can't tell you where to make that. I can only try to help you make an informed decision. Oscar asks about transferred intent for the rounds going the opposite way. Yeah, it's not really dissimilar from what I already talked about in the sense that it's not reckless if it's a justified creation of substantial risk. Recklessness, criminal recklessness, is an unjustified creation of a risk, substantial risk of death to another, deliberately ignoring that risk, death results. That's reckless manslaughter. The concept of transferred intent would work in a similar way, in that if you're lawfully firing at an aggressor, so you have good intent, lawful intent for firing at that aggressor, and a round misses and ends up hitting a innocent bystander, kills the bystander, your lawful intent for your intended target legally transferred intent transfers over to the innocent bystander, and there should not be legal liability for the unfortunate death of the innocent bystander, assuming you did not fire the rounds negligently. It transferred intent, for it to work in that positive sense, requires non-negligent conduct. If you're just doing a mag dump down the street and hitting innocent bystanders, that's on you, because that's arguably negligent. In the facts of this case, what I would expect the prosecutor to argue counter to a transferred intent argument is that it doesn't apply because you were negligent in blindly firing through the door. And if he can convince the jury it was negligent, then the jury would have to conclude that transferred intent doesn't apply as a doctrine. Let's see. Law self-defense member Tony's responding to another member says he's talking about defensive property. Can you only, he doesn't ask this question, but it raises the point. When we're talking defensive simple property, personal property, I mentioned Texas is the only state that has a legal provision for the defense of personal property with deadly defensive force. But there's a lot of variance across the states, even if you're just using non-deadly force. You can use non-deadly force to defend your property from immediate taking, but not to recover your property that was previously stolen. You can use non-deadly force to defend your property, but often nobody else's property, or your property and immediate family member's property. And then there's a legal definition of who's an immediate family member, and it may be stricter than you would think, but not a stranger's property. Or you may be able to protect other people's property, but only if you have a legal duty to protect that property, like your hired security. So there's a lot of variance across the states on the details of the privilege to use force in defense of personal property. Let's see. I don't know the current state of the case, folks. I've just seen the video. I haven't seen any news reports. And I'm only, my understanding, well, we know it was Dallas because the cops who arrive on scene tell us that. Dallas police. I love the way they say police. Police. All right, so let's take a look now at the, before we do that, let's take a look at this case because I think it's interesting. So this was a case out of New Mexico. This guy, the defendant, Cardenas, he was at home, and his buddy, I'll pronounce it as Lujan, his buddy came to the defendant's home, opened a screen door, started banging on the door loud enough to wake up the defendant. This was 1:30 a.m. at night. The defendant armed himself, demanded that the visitor identify himself. Maybe these are friends, so maybe Lujan didn't hear him. But the defendant didn't hear an answer. The intruder continued pounding on the door, and the defendant fired a single shot through the front door, killed his friend, Lujan, without knowing it was his friend. He was tried for voluntary manslaughter. This would be reckless manslaughter. He requested jury instruction on defensive habitation and involuntary manslaughter. The district court denied the instructions, and he was found guilty of voluntary manslaughter. He now appeals his conviction, asserting the district attorney the district court committed error when it refused those instructions. I'm going to focus here on the defensive habitation instruction because it's along the lines of what we have for Texas, that he was dealing with an unlawful forcible intruder in his home, and therefore it should be legally presumed that he had the privilege to use deadly defensive force. The district court refused to give that instruction on the grounds that it was not an actual attempt to break into the home by an intruder. In fact, it was just his friend trying to get his attention. And the district court, the trial court, said, no, you only get the benefit of the legal presumption if it's an actual attempt to unlawfully and forcibly break in. It doesn't matter if you simply believed it was an unlawful attempt to break in. It doesn't matter if your belief was reasonable. It doesn't matter what your perception of it was. The most reasonable belief that you were dealing with an unlawful and forcible intrusion is irrelevant unless it turns out to be correct. No reasonable mistakes here. It has to be an actual unlawful intrusion. And that's why the trial court refused to give the defensive habitation instruction, because this was, in fact, the guy's friend who was banging on the door, not an intruder. And the defendant appealed this, claimed this error, and the appellate court thankfully said that it doesn't have to be an actual attempt to intrude, that a reasonable perception of intrusion is enough, and that there was evidence to support that belief. So the belief was not irrational on the part of this defendant. There was evidence to support the belief. There was evidence indicating the victim was in the process of opening the door when he was shot. Expert testimony suggested that the door could have been anywhere between 1 and 4 inches open when the defendant fired the fatal shot. There was no evidence the defendant himself opened the door, so it's reasonable to infer that the victim did. One of the investigating officers testified he believed that the victim was trying to gain entry, blah, blah, blah. Lots of evidence. Now, the appellate court's not deciding whether or not this evidence is true. They're just saying there was evidence to support the argument, the defensive habitation argument, that a reasonable occupant inside the dwelling could have perceived an unlawful and forcible entry. And as long as there's facts to support a jury instruction, well, then it's up to the jury to decide whether or not they believe those facts. And they should be given that jury instruction. So, as is generally the case here, the appellate court is not saying, well, this guy should be acquitted. They're just saying, listen, there was evidence to support the jury instruction. The jury should have been given the instruction. It's up to them to decide whether or not they believe this argument. And they were not given that opportunity at the trial. So we're going to reverse the conviction, not let this guy go free, not announce him not guilty, reverse the conviction. Let's see. Yeah. Well, it doesn't say here, but generally they're reversing the conviction and remanding for a new trial. And in the new trial, the jury would be given that instruction. So here we have a trial court in New Mexico where the trial court said, no, it doesn't matter if you reasonably perceived an intrusion, it has to have been real. And then the trial court was reversed by the appellate court, said, no, reasonable perception of an intrusion is sufficient. We have a very different case. You may remember the case of Theodore Wafer in Detroit, Michigan. If you don't, we'll go over the facts real quick in this decision. So November 2nd, 2013, and this was a trial that I covered in real time, every minute of it. November 2nd, 2013, 4:30 a.m., the defendant, Theodore Wafer, shot and killed 19-year-old Renisha McBride on the front porch of the defendant's home. McBride had been in a car accident before the shooting. Almost certainly extremely drunk. It's uncertain how or why she came to be at the defendant's home. She probably thought it was a friend's home and they were joking with her, not letting her in. She had marijuana in her system and a blood alcohol level was 0.218, folks. And the trauma of having crashed her car. They found her crashed car a block or so away. 0.218, that's about 3 times the legal limit. So, a defendant admitted that he shot McBride. In fact, he called the police immediately after the shooting, but he asserted at trial that he did so in self-defense because he thought McBride was trying to break into his home. However, the evidence showed that McBride was not armed at the time of the shooting. Well, that would be irrelevant, right? That's completely irrelevant to whether or not she was attempting to break into the home. She possessed no burglary tools. Well, that's irrelevant. You don't need these two guys we just saw in the video. They didn't have burglary tools. Were they trying to break in? They sure were. The jury convicted defendant of second-degree murder, statutory involuntary manslaughter, and felony firearm. The trial court sentenced the defendant 15 to 30 years for the second-degree murder conviction and 7 to 15 years for manslaughter. This would be another issue on appeal, by the way, that he got convicted of murder and manslaughter, because those are really two different killings, and there was only one victim here. Murder requires malice, and manslaughter requires an absence of malice. So how do you get both? Spoiler, ultimately, the Michigan Supreme Court would reverse on the manslaughter conviction, leaving only the murder conviction, because it was an irrational decision. But the Court of Appeals would allow it, would allow for both. This same Court of Appeals decision we're looking at right now. So the defendant argues that the trial court committed error when it denied Wafer's request for jury instruction based on Michigan Consolidated Law 780-951, Section 1. This is the legal presumption in the context of highly defensible property. Very similar law to what we just saw in Texas. The difference is Michigan's law is a lot more ambiguous about whether or not reasonable belief is sufficient, reasonable belief of an intrusion. And what this Court of Appeals decides is that no, reasonable belief is not enough. It has to be an actual breaking and entering into the dwelling. And they decide, because Renisha McBride was not in possession of burglary tools, that there was no actual attempt to break and enter, and therefore Wafer doesn't get the benefit of the defensive habitation presumption. Now, in fact, I'll tell you, there was evidence consistent with the breaking and entering. So Renisha McBride was banging on the front door of Wafer's home, 4:30 a.m. Very violent part of Detroit, by the way. Lots of home invasions in this community. Wafer had reason to be concerned about home invasion. In fact, he kept a shotgun nearby, a pistol grip Mossberg shotgun. He was asleep in his Barca lounger in his living room, not far from the front door. So he wakes up due to this pounding. He's concerned. He grabs his shotgun. He goes to his front door. There's a pause in the banging. He opens up his front door, and he testifies someone lunges in the direction of the door, and that's when he fires the shotgun in self-defense and defense of habitation. Turns out to be the drunk Renisha McBride at the wrong home. Obviously, 12 gauge to the face, kills her instantly. Well, the evidence would show that there was the front door, and then there was a screen door, and the screen on the screen door had been punched inward, not outward by the shotgun blast, but inward. Well, that's breaking and entering. That's a forcible attempt to enter the home unlawfully. So there was actually evidence to support. But what the Court of Appeals decides is, well, we believe she was just a drunk girl, not actually trying to break into the home. So we're going to ignore that screen door evidence. And if she wasn't actually trying to break in, it doesn't trigger this legal presumption under Michigan law. So Wafer should not have gotten the instruction. The trial court was correct, and his convictions, the Court of Appeal says, for both of these is correct. Now, Wafer would then appeal to the Michigan Supreme Court, and the Michigan Supreme Court, it's interesting that they have two different decisions. One in 2018, where the majority of the court just says, no, we agree with everything the Court of Appeal said. There was a dissent by one justice on the Michigan Supreme Court on this issue of whether or not the breaking in has to be actual or only reasonably perceived. And that dissent does an excellent job of explaining why reasonable belief should be the standard. And why it would apply in this case, why reasonable belief is enough. By the way, I'm going to put links to all these decisions in the description of today's show for Law of Self-Defense members when the blog post version of this goes up. If you're not a member, you can look this stuff up yourself. Sorry, that's another benefit of being a Law of Self-Defense member. So that dissent said, no, reasonable belief should be enough under Michigan law. But that is a dissent. So the Michigan Supreme Court, right now in Michigan, you don't get the benefit of that legal presumption of a reasonable fear of imminent deadly force harm, someone's breaking into your home, unless it's an actual attempt to break in. Reasonable perception is not enough because of these Michigan cases. So There we are with Michigan. Now, why is that a bad idea? It's a bad idea because everywhere else in use of force law, reasonable perception is sufficient. Now, it used to be different, especially in the context of defense of others. So it was very common 50 years ago, 80 years ago, in a defense of others situation. So you're not defending yourself, you're defending others. Remember, we have the same 5 elements. Framework applies in both defense of self and defense of others. Defense of yourself, it was always the case that reasonable perception was sufficient. You didn't have to be correct about these things. So if you were threatened with a fake gun that couldn't actually kill you, but you reasonably perceived it as a real gun, you're making a mistake, right? You think you're facing a real gun, but you're not. But if it's a reasonable mistake, that's fine. Reasonable mistakes are okay in defense of self. It used to be different for defense of others. It used to be that in the case of defense of others, about half the states would say, if you come to someone else's defense and it turns out you were mistaken in your perception about what was going on, that mistake is okay if it's a reasonable mistake. So you turn a corner, you see 2 guys, 2 scruffy looking guys grabbing a woman, and she's screaming for help. Help me, I'm being kidnapped, I'm going to be raped. And you kidnap and rape are deadly force offenses. If it was happening to you, you could use deadly force in self-defense. So you whip out your pistol, you take those guys at gunpoint to save that woman. But then it turns out those 2 scruffy guys are not kidnappers and rapists. They're 2 undercover DEA agents making a lawful arrest. Well, under the reasonable perception standard, if you could not have known that, there's no badges displayed, that kind of thing. As long as your perception of a kidnapping and rape was reasonable, even if mistaken, well, then your defense of others was still good and you're free of criminal liability. But there was also another standard called the alter ego standard that did not allow for reasonable mistakes. The alter ego standard said that your privilege to use force in defense of that other person is only as great as their own privilege. Well, under the alter ego standard, because that woman would have no privilege to use force to resist a lawful arrest, you would have no privilege to use force on her behalf, no matter how much you reasonably believed a kidnapping and rape was taking place. All that would matter would be the actual facts. Every state has done away with that standard and switched over to reasonable perception being the appropriate standard. Why? Because it's the only thing we can ever use to guide our conduct, folks. Nobody ever knows truth in an absolute sense. We're all always relying on our perceptions, and all we can ask is that people use reasonable perceptions. Not have some omniscient, ultimate, perfect understanding of truth. None of us have that. It's impossible. So in defense of others, every state has gone away with that rigid, alter ego, no mistakes allowed approach. You're allowed to make mistakes in defense of others as long as your mistake is a reasonable mistake. And as we saw in Texas, with the legal presumption of a reasonable fear of imminent deadly force harm in the context of defense of your castle, the question is whether you knew the intrusion was happening or you had reason to believe. So it has to be reasonable. It can't be a speculative fear that there's an intrusion. There have to be facts to which you're applying your powers of reason. But if there are, and you evaluated those facts in a reasonable way, even if it later turns out you were mistaken, that's sufficient. So this Michigan decision is going completely counter to this decades-long trend of moving away from requiring absolute correctness to requiring a reasonable assessment of what's happening. Why? Well, this was a highly politicized and racially energized case. Theodore Wafer was white in his home. Renisha McBride was a young black woman in Detroit. So all the usual suspects came out. The prosecution made a lot of reprehensible arguments in this case, really suggesting that Theodore Wafer was just, he was angry at the black people for living in his neighborhood, and here was another black person who woke him up and he was going to make her pay. Those are the kind of arguments that were made. And of course, there are all the usual protests and all the usual implicit violence and danger to the jurors if they don't convict. And all of those political and racially energized pressures also apply to judges. Judges have to worry about the political consequences of their decisions too. We see that in many, many cases that we cover, these high-profile cases. And the Court of Appeals is not going to be immune to that, particularly since the Court of Appeals eventually, they would like to be on the Michigan Supreme Court, right? So if they're ever nominated, they don't want the press to start talking about how they saved that racist Theodore Wafer who killed a young black woman just because he was in a bad mood. And of course, the Michigan Supreme Court wants to protect their legacy too. There was that one brave member of the Michigan Supreme Court who did actual substantive legal analysis on this question of, do you have to be right about the intrusion, or is reasonable belief enough? The other members of the Michigan Supreme Court wrote not one word on that issue. What does that tell you? All right, so good heavens, I might be running out of stuff to talk about. Well, when that happens, it's always a safe bet to remind all of you that we only take questions and comments during our live streams and elsewhere from our actual Law Self-Defense members. I'm going to do that right now. I'm going to look at the Law Self-Defense member chat, because these shows are live streamed on YouTube, Rumble, Twitter, and on the Law Self-Defense member dashboard. And there we have a chat function, as you might expect, where the members can ask questions, talk with each other, make comments. We don't take comments and questions from YouTube, Rumble, or Twitter, only on the Law Self-Defense members chat. Good news, you can become a Law Self-Defense member right now for 99 cents. 99 cents, folks. Gets you 14 days, 2 weeks, unlimited access, just as if you were a full member, to all our members-only content, to the questions and chats, to the videos that we don't put on YouTube because they're too violent and we get demonetized, to the entire shows we do that are members-only shows that never see YouTube, Rumble, or Twitter, to the transcripts we have of every show that you can read if you prefer to read rather than watch videos, and download for your own records so you can document your specialized knowledge on use of force law, should that become necessary to your legal defense in court, and it well might. You get all those benefits for 99 cents for 2 weeks at lawselfdefense.com/trial. And if you stay a member, it's still dirt cheap, folks. It's 30 cents a day. Almost every day of the week, I do an hour, hour and a half, 2 hour show like this. You get that for 30 cents. I think it's a pretty good deal. 30 cents a day, less than $10 a month to be a Law of Self-Defense member. But try it out at least for 2 weeks at lawofselfdefense.com/trial. All right, so back to the member chat. Here we go. Let's see. Eric asks, with respect to the Cardenas case, that was a New Mexico case where it was the shooter's friend on the other side of the door. And the state's arguing there was no actual attempt to break in. It was just the guy's friend trying to get attention. And Eric asks, Law Self-Defense member, Eric asks, can the state really make that claim? Is it not possible the state was trying to break in? Friends do kill one another. Sure, that's possible. But it's only possible. And the state is free to make the claim that that wasn't what was happening. And then the defense would make the claim that was what was happening. So the evidence can support a variety of arguments, and the state chooses the ones they find most favorable. And that's why we have an adversarial process in courts. The state can argue almost anything. I mean, if there's a scintilla of evidence that from which they can make an inference for some legal argument, they're free to make that argument. Once there's more than zero evidence, they're free to make that argument. Law Self-Defense member Dave refers to Florida statute 776013, following words which describe the action entering into in the process of, well, I'm sorry, Dave, I'd have to pull up the actual statute, and I don't know how handy I have that. Let me see. I used to have shortcut links to all those statutes. And I do. All right. Well, let's go ahead and take a look at the Florida law then. See how it differs just for educational purposes. So let me move this like that. Let me make this larger so it's legible. So here's the Florida equivalent of the Texas statute we just looked at, right? 776013, home protection, use of threatened use of deadly force, presumption of fear of death or great bodily harm. So a person who is in a dwelling or residence, like Texas, it has to be occupied, right? You're not outside your home observing from the exterior when you know there's no one inside the home. You live alone. It's the person who is inside the dwelling or residence has a right to be. Looks like there's a typo here. Has no duty to retreat. So of course, that's not only the that would apply by castle doctrine anyway, but it happens also to be Florida's stand your ground language that's interspersed in a number of Florida statutes. Also, their defensive persons statute has that same language. No duty to retreat, has a right to stand his or her ground, and use or threaten to use, well, we're mostly interested in deadly force. Deadly force, if he or she reasonably believes that doing so is necessary to prevent imminent death or great bodily harm to himself or another, or prevent the imminent commission of a forcible felony. So this first paragraph is simply a restatement of self-defense. That's just the 5 elements of self-defense. It doesn't really require, the same would be sufficient even if you were not in a dwelling or residence. If you were on the street, these conditions would be sufficient to justify the use of deadly defensive force. Here comes the special provision for the use of deadly defensive force in the context of highly defensible property. A person is presumed to have held a reasonable fear of imminent peril of death or great bodily harm. Reasonable, imminence, proportionality. To himself or another when using or threatening to use defensive force that's intended to cause death or great bodily harm if, so now we meet the conditions that are required to trigger this very nice legal presumption that just gave us 3 of the 5 elements of self-defense. The Castle doctrine and stand your ground removes avoidance in an otherwise lawful case of use of force. So avoidance is off the table. That's 4 of the 5 elements of self-defense. Innocence is kind of baked into the cake anyway if you're defending yourself in your home from an intruder. So let's look at the conditions. If the person against whom the defensive force was used or threatened was in the process of unlawfully and forcibly entering, had unlawfully forcibly entered a dwelling, residence, or occupied vehicle, or, and then we have the kidnapping scenario. So this would suggest to me that the entering has to be happening, that a reasonable perception is not sufficient, right? It's not the Texas language, knew or had reason to know. But we fix that problem when we get to this. At least I think we fixed the problem. And the person who uses or threatens to use that defensive force knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring or had occurred. Now, my preference would be for this had reason to believe language to be in this upper paragraph 2, or even to proceed, be in this introductory section to another if the defender knew or had reason to believe. That's how Texas does it. Texas puts it up here before the subparagraphs. When Florida puts it only in this second paragraph, an aggressive prosecutor might argue that it only applies to the second paragraph. That what this is saying is that there has to be an actual unlawful and forcible entry, and that this is a completely independent provision of that. That the purpose of this provision is to prevent the defender from not knowing or having reason to know and claiming the presumption after the fact when they gain new knowledge afterwards. They don't know there was a broken door or a broken window until the next day. So at the moment they're using defensive force, they did not know or had reason to believe. In other words, they don't want to give the benefit of the legal presumption retroactively. They want there to be an actual breaking, and you knew there was an actual breaking. That's how I would argue this if I were the aggressive prosecutor. And then, like the Texas statute, we have all the exclusions. You could qualify for the legal presumption and then lose it if you trigger any of these exclusions. Texas does this, Florida here does this in the more typical fashion, a little bit different than Texas did. The person against you're using the force is also, they're a co-dweller, they're a lawful resident, they're allowed to be there, they're not actually an intruder. The person in the kidnapping scenario, it's not really a kidnapping. The person during the taking has custodial rights. You're using the home, the dwelling, for criminal activity. You know, you're dealing drugs out of the home, you don't get the presumption. Or the person against whom you're using the force is a law enforcement officer who's in the course of their duties and conducting himself in a way that you should know. You knew or reasonably should know that they were a law enforcement officer. So that's how Florida structures all that. Okay, back to the chat. Let's see. Steve is in the chat, so maybe he has some thoughts on Florida 776013 and this question of actual or reasonably perceived threat. Let's see. So law self-defense member Royce says, in the case of the hypothetical with the DEA agents trying to make a lawful arrest, wouldn't they have to have some kind of identifying markers? No. Nope, they don't. And maybe they do and you don't see it. Right? So if the question is your subjective perception, maybe they showed the woman badges when they initiated the arrest, but now they're in the tumult, the badges aren't obvious. They're hanging on lanyards or they're mounted on the belt and now they're obscured from your vision. The question under the alter ego standard would only be, are they actually cops? Not whether you had reason to know they were cops. Tony asked, don't some states still use the alter ego? There is one state, South Carolina, where if you look at the case law, the court decisions, it still suggests alter ego. But all those cases are more than 100 years old. And I would expect if a new case were to occur, that South Carolina would adopt the dominant modern standard of not applying alter ego, applying reasonable perception. It is true, their case law that's still on the books, and case law that's 100 years old is still valid case law. But my expectation would be that it would not be, that standard would not ultimately be applied. Now, the trial court might apply it because trial courts are constrained by what the case law actually is. Trial courts don't really get to decide, that's 100 years old. It would be an issue that would have to be settled by the appellate courts, which means you might get convicted and spend 8 or 10 years in prison before you get your conviction reversed. Let's see. Okay, I think those are all the substantive comments. So, folks, with that, I will begin to wrap things up. For those of you who are new to law self-defense, I will mention that we have a very popular best-selling book, Law Self-Defense Principles. It's a real physical book, folks. It's not just some PDF download. I urge you to check it out on Amazon. If you look up Law Self-Defense on Amazon, you'll see that all our books are 5-star rated. There's well over 1,500 reviews. 5-star rated books, but don't buy it on Amazon. Amazon will charge you $25 for the book plus shipping and handling. We'll give you this book for free. We do ask that you cover the shipping and handling. So the $8 or so that it requires to get the book in your hands, that's not profit for us. That's just money to go to shipping and the guys in the warehouse who need to be paid too. But we'll give you the book for free. We'll eat the cost of the book. You can get this book at lawofselfdefense.com/free book, and it provides a thorough education in the law of self-defense, including each of the 5 elements and lots of other stuff as well. Oh, I'm not actually done. I forgot. I wanted to take a look at the police. I forgot about the police. We're done with the use of force law stuff. Let's now take a look at, I have some quick thoughts on the police segment of all this. So, the bad guy's kicking in the door. We're going to hear the gunshots. They're going to run away. And then there's going to be a skip in the video, and it goes to the police announcing themselves out in the hallway. So here we go. By the way, I take something back. It doesn't look like he was deliberately trying to miss, right? Because when the shots start, where's the bad guy? I mean, he kind of ducks, but look at that. Look at how close those misses are right there. Oh my gosh. He's missed by inches, maybe a fraction of an inch, depending on the actual angle. He is one lucky SOB. You think that was a mag dump? You think that gun's empty right now? Slide lock? I bet it is. Had that feel to it. All right, so now we're going to have the cops.
Yeah.
Dallas police. I love that. Dallas police. Look at that taser, by the way. Taser's nowhere near his pistol. Right?
Mr. Rodriguez, Ethan, it's Dallas police.
Hey, they shot back. There's shell casings out here.
Focus on the web for his
Whoop.
nowhere near his pistol right. Check it out.
Oh, for God's sake. Siri is... Somehow I triggered Siri on my laptop. Okay. Now the cops are observing, by the way, Brass out in the corridor, which suggests that the guy we know now had the gun in his hand, the guy in blue with the blue bandana, that he may have started firing back. I wonder where his bullets went. But that's, of course, not the responsibility of the apartment owner.
Right here, open the door. Yeah, just open the door slowly, man. Make sure I can see your hands.
All right, open the door slowly. So the camera's obviously mounted on the door. The door's hinged on the right. It's being opened on the left. Yeah, man, open the door slowly. Get your hands in sight as quickly as possible. In fact, one criticism I have here of the apartment dweller is he's got his hands pretty well in sight when he steps out, and then he drops them real quick. I wouldn't be doing that. My hands would be up until the officers told me it was okay to lower them.
We're all in. We're all in. Come on out, man. Are you the only one inside? No, my brother. All right, I don't want all of you guys to come out.
Oh, there go his hands. I'm not dropping my hands right there. These cops might be nervous. Listen, departments are having a hard time hiring people, much less quality people. No, my hands are staying way up.
All right, can I get my phone? Video? Yeah, okay.
All right, so now he says, can I get my phone? I want to show you a video. So they've called the cops. Obviously, there was a clip in the video, so there's been some time delay, of course. So during the time delay, the apartment dwellers obviously looked at his phone. Let's pretend this is a Ring camera. I don't know. And seen on the app that he's got the footage. So he's really eager to show the cops this footage, which, you know, people always ask me, what about cameras? Are cameras a good idea? Cameras helpful to self-defense? What about body cameras? Cameras in a car? Should I put cameras everywhere? And the answer always is, folks, well, the cameras are very helpful if they only capture exculpatory evidence. If your cameras capture incriminating evidence, then they're not helpful. Right? So it all depends on what you do. In this case, the cameras are going to show those two guys, gun in hand, aggressively trying to kick in the door, so it'll be helpful. But I'm not sure the homeowner is in, unless they've educated themselves, is in a good position to really know whether or not the video is going to be exculpatory or incriminating. I mean, most people don't know what the actual law of self-defense is. For example, if it's certainly proof positive that these guys fired through their door, but I guess presumably the bullet holes would be enough for that anyway. So they want to show the video because they believe at least that the video is exculpatory. And it's certainly exculpatory in the context of what wasn't a break-in actually in progress. So this cop with the flashlight was just looking at he was looking for bullet holes in the other door. He's thinking reckless endangerment. He's thinking maybe we got to go in there and see if there's a dead body in there. Right? And you do. I mean, maybe they're just injured. Maybe they're not dead. Maybe they're bleeding out on the floor. I had a case where a guy was dry firing his pistol at home, and he goofed, and the gun discharged, and wasn't a good backstop. The round went right out the window, struck his neighbor's house, and punched through the garage wall of his neighbor's house. And he called me rather frantic, not sure what to do. Well, the first thing you need to do is go to that house and make sure that round didn't strike someone in the garage. Because if they're injured, you don't want them to die. I mean, you don't want them to die just from a normal human perspective. You don't want an innocent person to die, of course, but also in terms of your own legal liability. Maybe your conduct was reckless. Maybe it was just negligent. Maybe it was just accident. That's for others to decide. But whatever the appropriate, correct mental state might have been involved in that discharge, your legal liability obviously goes up if the result of that was a death of an innocent person, as opposed to an injury or an endangerment. So now they're going in the house, right? These guys gave I presume they gave permission to go into the house. One of the concerns here would be, of course, if these two guys were drug dealers, right? Because if you're using the apartment for criminal activity, you wouldn't get the benefit of that legal presumption. So now they're knocking on that other apartment door outside. Want to make sure no one's injured. And that's finally the end of the video. Now, these guys are chatting with the cops. They think they did the right thing, the apartment dwellers, and they want to share that information with the cops. Generally not a good idea to get into detailed conversations with the police, especially after a deadly use of force event without legal counsel present, maybe not even then. When we do our law self-defense full day courses, we spend almost an hour talking about interacting with the police in the aftermath of a use of force event. Just checking when the next one is coming up. Well, folks, the next one is coming up pretty soon. So this is our full day course, and it's coming up the next live course. So I teach this live. Saturday, October 7th, 2023. We spend 7 hours, sometimes more, depending on how much Q&A there is. 7 hours, in-depth, the most intense instruction on self-defense law available, except for our law self-defense instructor program. That's another level. This is essentially the same content I use to teach use of force law to other lawyers. I'm accredited to teach continuing legal education in most of the country. And this is the same curriculum we use for lawyers, but we teach this in plain English as opposed to legalese. So if you're interested in learning more about this, you can go to lawofselfdefense.com/advanced for our advanced class, Saturday, October 7th, 9 a.m. to 4 p.m. We have a couple different packages you can look at, but you'll see all that at the site, lawofselfdefense.com/advanced. I don't know if I have a banner for that or not. I mean, of course I should. There's really no excuse for not. I do. Right there. There it is. lawofselfdefense.com/advanced to sign up for, learn more, sign up. Well, I think on this webpage, we also have a list of 100 use of force law questions that we answer over the course of the class to give you a sense of the scope of it. But we spend almost an hour, I think 45 minutes roughly, typically talking about interacting with the police in the use of force event. And it's more subtle than simply saying nothing, folks. In fact, simply saying nothing can create legal jeopardy for you. So if you don't know that stuff, it would be helpful, I think, for you to know it. So lawofselfdefense.com/advanced. Oops. All right. So one last look at the member chat. Yeah, one of them was about police interaction. So I just addressed that. Law self-defense member Royce. And again, folks, we only answer questions from law self-defense members. So take advantage of that trial offer to be a member. 99 cents, 200% money back guarantee, zero risk. And once you are a member, it's still only about 30 cents a day, less than $10 a month at lawofselfdefense.com/trial for the trial membership, 99 cents. Did you cover the attempted carjacking of a police officer in Louisiana when the suspect was shot by the cop? I don't think so. It doesn't ring a bell, but as you might imagine, over 31 years, I've covered thousands of these cases. So, oh, you have a link there. All right. So I will take a look at the link after the show, Royce. Thank you for that. Let's see. Royce also says, different topic suggestion. Can you do a show on how people post comments on Facebook and YouTube about how they would shoot someone or how someone, a road rage situation, would get lead pumped and how that would be used against them in court? I'm not sure I need a whole show, Royce. I mean, I'll just tell you, when I consult on cases and I get the discovery file, the first thing the authorities do is subpoena all the social media of the defendant, all of it. And I get all of it in the discovery file. And all that stuff that was like deleted, it's all there. It's all there. And those social media companies, the phone company with your text, they cough up that stuff. They get that subpoena, sometimes even without a subpoena. But certainly they get a subpoena, they cough all that up instantly. The prosecution gets all of it, including the stuff you think you deleted. Nothing's ever deleted, folks. And the prosecution will put on it the worst spin possible in front of the jury. I mean, we saw that in the Rittenhouse trial, right? With Binger pulling up Kyle's social media. And Kyle had stuff in there like, I don't know. I'm not that familiar with all the social media. I don't know if it was TikTok or Instagram or what, but he had a moniker with a car, 4-door sedan. It said 4 doors, more whores. Surprising for a teenage boy? No. A good look for the jury? Not great, right? And of course, the prosecution will use every stick you give them to beat you with. Let's see. Zachary asks, would calling the police and telling them you fired shots in self-defense from your house create exigent circumstances where the police could search your house without your permission or a warrant? I mean, the argument they would make, of course, is that the house is now a crime scene and they're allowed to investigate a crime scene. So could they search your entire house, roof to cellar? Probably not. Could they start opening up drawers and stuff? Probably not. Can they step into that room, the room from which the shots were fired, and look around? Probably. But, you know, this is not an evidence show. This is a use of force law show. You should presume that they're going to come in. You should presume, by the way, they're going to come in and search your whole house. And there's nothing you can do to prevent that. I mean, what are you going to do? Get into a gunfight with the police so they don't search your house? The solution to them doing that is you would complain to your legal counsel, and your legal counsel would attempt to get whatever they discovered excluded from evidence. So that's an argument that's made after the fact by your attorney, not by you. And you know, right? Someone, Richard, law self-defense member Richard, reminds me that Binger's own email was Fluffer Boy. Whether or not the police need a warrant to do anything is something that's determined after the fact. The police are doing what they're doing in the moment. Now, if after the fact it turns out they needed a warrant to do that, you can get the evidence excluded. But again, that's a decision made after the fact. Now, the police are supposed to know, have a reasonable understanding of when they're supposed to have a warrant and not. I mean, in theory, their decisions in the moment would be the same as would be decided later was appropriate, but that's not always the case. And some cops are not that well trained or don't give a crap. So, you know, when the cops show up, they've got guns. What are you going to do in the moment to stop them from doing what they want to do? It's just like with unlawful arrest, right? If a cop wants to arrest you, maybe it's an unlawful arrest. Maybe it's against the law for them to do that. Are you going to fight them over it in the moment on the side of the street? Or are you going to comply with the arrest and then sue them afterwards? Okay. All right, folks. Now I think we're really, really done. So thank you so much for joining me. Another hour and 40-minute show. Holy cow. I've got to fix this. But in the meantime, remember, folks, if you carry a gun, so you're hard to kill. If you carry pepper spray, so you're hard to kill. Carry a knife, so you're hard to kill. If you learn BJJ, and I'll be rolling on the mats tonight at tonight's evening class because I missed yesterday's lunchtime class because I was delivering a show to all of you. If you do all those things, gun, knife, pepper spray, BJJ, like I do all those things because I want to be hard to kill. I want my family to be hard to kill. then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. That's what we try to help you do. Know the law so you're hard to convict. Not through tricks. We don't do legal tricks here. But by knowing the actual law of self-defense, defense of others, defense of property, so you know where the legal boundaries are, you stay well within them. That's the only way to make yourself hard to convict. That's why we're here. All right, folks, until next time, I remain attorney Andrew Branca for Law of Self-Defense. Stay safe.